Are we live? I think we should be going live. I'm green up there, and we now have a live connection here. Hello, everyone. Welcome. Good afternoon, good evening, good night, good morning. I'm Leonard French, your favorite copyright attorney, but you could be forgiven after this story if you want to add a +1 to your favorite copyright attorneys, because the Kleins have hired an attorney in California who has filed this epic, absolutely epic motion to dismiss. Really quick, just a quick summary of what we've got going here. Triller Fight Club has filed a lawsuit against H3 for showing a clip of the Ben Askren Jake Paul fight a number of months ago. I care so little about that fight that I actually kind of forget exactly when it was. They're going to go over it in the documents, but then in May, Triller filed a complaint and then eventually amended that complaint to include the Kleins and TED Entertainment, and then I think they may have even amended it again. But now we're all the way down here at September 6th. The second amended complaint on July 23rd, and then September 6th we have this notice of motion to dismiss. And my cat has decided to start climbing on things next to me, so this is going to get interesting very quickly for everyone. But there's a lot here, and it's really interesting, so I'm going to go through the one motion to dismiss memorandum in detail, but we're going to start here with what they have filed: a motion to dismiss plaintiff's second amended complaint pursuant to FRCP 12b6, that's Federal Rule of Civil Procedure 12b6, which is failure to state a claim upon which relief can be granted. And it's been filed by an attorney named Lincoln Bandlow, and he is my opposing counsel in the Strike 3 Holdings cases, the cases where people are getting sued for BitTorrent downloads. And I'm not going to talk about that because this is about h3h3, and they say that plaintiff Triller's claim fails to state facts to plausibly state a claim for relief and fails under the doctrine of fair use. There's also claims for vicarious copyright infringement and for violations of the Federal Communications Act. I went over a lot of this in an earlier video. The FCA Communications Act violations are based on like retransmitting cable TV signals, that kind of thing. So you're going to see that discussed here as well. So without further ado, here we have the Lincoln Bandlow filed or drafted and filed motion to dismiss. Here's the memorandum and points of authority and all that. And, you know, this is all great. It's very well formatted. It's got a lot of citations, but we don't really care too much about the citations. There's going to be a couple in here that I think you'll really enjoy, but let's just get to it. Introduction. The second amended complaint of Plaintiff Triller Fight Club II's is fatally defective on its face. The second amended complaint, which is going to be called the SAC here, is Triller's fifth attempt to draft a well-pled complaint regarding defendants' critical use of the Triller broadcast entitled Jake Paul v. Ben Askren in the TEI produced H3 podcast. I think it's TED Entertainment Incorporated. Despite numerous opportunities, Triller consistently files complaints that are mangled and a mangled and mangy mess that are devoid of any merit. I told you this was going to be interesting. My cat is now climbing into the bag next to me, and it's very distracting. Would you like to get out? She wants to leave. She's just going to leave. We're just going to give the cat a chance to leave. There we go. Okay, now back to our story. Triller's persistent failure to properly plead a complaint is particularly egregious. In response to Triller's previous attempts, the Honorable Percy Anderson dismissed defendants sua sponte, which means the court did it on their own, for improper joinder because Triller relied on the barest legal conclusions without any well-pled factual allegations that call into question the adequacy of Triller's compliance with its pre-suit investigation obligations under Federal Rule of Civil Procedure 11, Triller's second amended complaint merely confirms Judge Anderson's suspicions. So this is swinging. This is a fight right out of the gate. Lincoln and H3 are really going after these allegations, saying that they are bare bones allegations. They are not well pled, and they're giving the history right away. Triller's second amended complaint centers around Ted's use of an excerpt of the broadcast for purposes of commentary and criticism. So fair use in the YouTube video entitled Jake Paul Fight Was a Disaster, H3 podcast number 244. They're going to consistently refer to that as the 42221 podcast. To facilitate the podcast's commentary and criticism of the broadcast, the Jake Paul broadcast, the fight broadcast, TEI employees watched the broadcast. Afterwards, TEI uploaded an excerpt of the broadcast onto YouTube as an unlisted video. So there's an allegation. We were wondering where the re-upload came from, and they're saying that TEI employees did upload the excerpt so that it could be accessed via hyperlink or manually entering the URL. Triller's second amended complaint alleges that defendants' conduct constitutes copyright infringement, vicarious copyright infringement, violations of the Federal Communication Act. Triller seeks to hold Teddy Fresh, Ethan, and Hila liable by alleging that TEI is their alter ego. We called that piercing the corporate veil, and that's going to be addressed here, so I'm not going to address it too much more, but it allows you to bypass the corporate form and get at the individual principles. Anyone who watches the 42221 podcast can instantly recognize the true purpose of Triller's second amended complaint. Retaliation against the podcast because it excoriated the broadcast and its main event, the boxing match between Jake Paul and Ben Askren. In other words, Triller's second amended complaint is a brazen and unabashed attempt to intimidate, punish, and silence lawful and protected criticism. This is emphasized by their parent company also suing defendants for tortious interference after the H3 podcast criticized and commented on the present lawsuit. Its parent and its parent company and its owner, Ryan Kavanaugh. This is not the first time Ethan and Hila have been the victims of an abusive lawsuit that seeks to punish and silence their lawful criticism. And here's where it gets good. The Kleins have already been to court once over fair use, and they made case precedent. They made groundbreaking case precedent on fair use on YouTube videos and sort of the reaction and commentary, the format that Ethan used in some of his videos. Rather, both lawsuits are hauntingly reminiscent of Ethan and Hila's prior lawsuit, the Hoschenjede versus Klein, the Matt Haas lawsuit. In that case, the court found that Ethan and Hila's use of 60% of another YouTuber's video for purposes of commentary and criticism constituted fair use. The court also found that their criticism and commentary was completely lawful. This case stands on firmer ground than the Matt Haas lawsuit because the 42221 podcast only used 0.3% of the broadcast to criticize and comment on it. Triller's remaining claims are defective as well, not only because they are comprised of threadbare recitals and legal conclusions, but because the SAC unequivocally demonstrates that those claims fail as a matter of law. So it's kind of a weird way to say it, but it's valid legal language, but saying that the complaint fails is a way of saying that it must be dismissed because it's not properly alleging a claim that a court will be able to grant relief on. It's a weird way of saying it, but what it just means that the complaint is defective. It is time for Triller's abuse of defendants as well as the judicial process to come to an end. For these reasons and those set forth below, defendants respectfully request this court dismiss Triller's second amended complaint with prejudice. So really, like the fight should have been, it comes out swinging, and it's really doing a great job so far. Let's continue. The complaint, I'm just going to call it the complaint. The complaint is not a paragon of The complaint is not a paragon of clarity, but the following can be discerned from its allegations. Triller alleges that it is the owner of a copyright in the broadcast published April 17th, 2021. Triller further alleges that it transmitted the broadcast to authorized third parties for retransmission via online platforms. Triller alleges that defendants' wrongful conduct was watching a pirated or bootleg version of the broadcast, uploading the reference video as an unlisted video to YouTube, and showing the URL of the reference video as an excerpt. In the screenshot provided by Triller, the URL of the reference video is illegible, and Triller failed to provide the URL for the reference video. Triller alleges that defendants profited from their purported wrongful conduct because the H3 podcast are part of the YouTube Partner Program, contain sponsorships, and sell merchandise. Basically, they made money. Based on this alleged conduct, Triller attempts to plead 3 claims for relief: copyright infringement, we got that already. Triller also seeks to hold we got that already. The broadcast is a 4-hour-long audiovisual work comprised of 6 boxing matches, including the fight at issue here, musical performances by prominent musicians, the Black Keys, Diplo, Doja Cat, Justin Bieber, Major Lazer, Saweetie, Snoop Dogg, Ice Cube, Too Short with a $sign, and E40, and interviews of the boxers by comedian and Saturday Night Live star Pete Davidson. On April 18th, 2021, the reference video was uploaded to YouTube as an unlisted video to the Zach the Sound Lad YouTube channel. As defined by Google, an unlisted YouTube video can only be accessed by having the URL for the video and not through a channel's list of uploaded videos or through YouTube search results. The reference video was under 14 minutes long and contained the prologue of the fight itself, and its aftermath. The reference video did not contain sponsorships or offers to sell merchandise. The reference video was not monetized as part of the partner program. To be eligible for that program, YouTube requires more than 1,000 subscribers. ZTSD has not met that requirement. April 21st, the over 2-hour-long 4/22/21 H3 podcast entitled Jake Paul Fight Was a Disaster, H3 podcast number 244, was uploaded to YouTube. Nearly 3/4 into the podcast, the cast of the H3 podcast began commenting on and critiquing the fight and broadcast, including its participants, for approximately 12 minutes. In the middle of this cast's commentary and critique, the podcast played 42 seconds of the reference video, which was comprised of 5 seconds exclusively of audio, 9 seconds of both audio and video, and 28 seconds exclusively of video, with 6 seconds comprised exclusively of video being repeated. Details are important. The podcast never zoomed in on the URL for the reference video. No cast member instructed viewers to watch the reference video or directed viewers to the URL or stated the video's URL. The only way to identify the reference video's URL is to watch nearly an hour and a half of the 4/22/21 podcast, pause the podcast when the URL appears, zoom in on the URL so that it's visible, and manually write down the URL, which is written down for you here, and manually enter the URL into an internet browser. The reference video received only 65 views. In the podcast, Ethan states that TEI employees watched the broadcast via a link through the internet. This is Triller's 5th attempt to properly draft a complaint. They go through the history, but basically they sued Film Daily, then they tried to add a bunch of defendants, and the judge dismissed those defendants for improper joinder. Joinder is when you have multiple defendants, but they have to be basically guilty of the same crime. They have to have the same transaction or occurrence, the same facts involved, the same legal claims, the same defenses, within reason. There's some wiggle room here. You can go read Federal Rule of Civil Procedure 19 and 20 for required joinder and improper joinder, or a permissive joinder. And so if you've got different people with different facts, somebody uploaded it to their channel separately from the H3 podcast, unaffiliated with that. Somebody else watched it on Twitch or something. These are all separate transactions or occurrences and not proper for joinder as multiple defendants in one action. But it is a way to save money. If you, the plaintiff, can put everybody together in one action, you just have to pay one $400 filing fee instead of multiple $400 filing fees, and then have to pay your attorneys to maintain multiple actions, which you'll have all the steps then have to be done multiple times. So Judge Anderson dismisses for improper joinder. Triller files a complaint against H3. I've covered that in a previous video, which should be in this playlist if you want to go back and review that. Every version of Triller's complaints were merely cut and paste rehashes of the initial complaint in the film daily action. It's fair to bring that up as a defense, but at the same time, really, what did you expect? Of course, they're going to copy paste their allegations and then do a little bit of tailoring for whatever happened. If everybody's got mostly the same facts and you're trying to join them all together, even if you were later unsuccessful, if you then break out into 5 or 6 lawsuits to sue everybody, or in this case, I think it's just 2, yeah, you're probably going to minimize your work and copy paste stuff. It's really not a lot wrong with copy pasting things in the law as long as you review them and they're still accurate for what allegations you're making. The sole additions were naming TEI as a defendant and including Ethan and Hila as defendants based on the alter ego theory and identifying the reference video. On June 29th, the defendants sent a detailed meet and confer letter to Triller demonstrating how each claim in the complaint failed as a matter of law. And there's a declaration from the attorney to show that they did that. Triller submitted its proposed second amended complaint, its 5th attempt to draft a complaint against defendants. The proposed second complaint contained nominal additional allegations, dropped 3 claims, and added Teddy Fresh as a defendant under an equally threadbare alter ego theory. On July 14th, counsel for the parties met and conferred telephonically about the defects. Triller was unpersuaded by defendants' argument regarding the fatal defects of the proposed second amended complaint. To avoid burdening this court with an anti-SLAPP motion and addressing claims that Triller effectively conceded lacked merit, defendants stipulated to the filing of the second amended complaint, which this court granted. On July 19th, Triller filed an action against defendants in Los Angeles Superior Court alleging tortious interference in another case. So Triller versus TED Entertainment. So this is now a California state law case in California, Los Angeles Superior Court. Another lawsuit against, this time, TED Entertainment, Inc. This action targeted statements made in various H3 podcasts criticizing Triller, its parent company, and its majority owner, Ryan Kavanaugh. Defendants shall respond with an anti-SLAPP motion on September 8th. So that's tomorrow, and I guess we'll try to find that, or maybe I can ask Attorney Bandlow for a copy of that. But a SLAPP or anti-SLAPP motion. The states have laws, fairly recently enacted laws, against public participation lawsuits. So SLAPP stands for Strategic Lawsuit Against Public Participation, and it's basically using a lawsuit to prevent someone from speaking or scare them away or chill their free speech is a way of saying it. So an anti-SLAPP law allows for an anti-SLAPP motion asking the court to dismiss the case, saying that it's a baseless lawsuit just to chill the entities or persons' speech or ability to publish something on the subject. So not complaint. So the dismissal motion goes into how a well-pled complaint would be able to survive dismissal. It's a requirement under Federal Rule of Civil Procedure 8, and you can file a dismissal motion under Rule 12 if the plaintiff fails to allege enough facts to state a claim that is plausible. It's important, that word plausible. It can't just be merely possible. This is my argument with the BitTorrent lawsuits, but the standard for all lawsuits is plausibility versus mere possibility. The plausibility standard is not akin to a probability requirement and instead asks for more than a sheer possibility that a defendant has acted unlawfully. In particular, this requires Triller to include enough facts to raise a right to relief above a speculative level. In stark contrast to Triller's fatally defective complaint, a well-pled complaint must contain sufficient factual content that allows the court to draw reasonable inferences that defendant is liable for the misconduct alleged. Instead, Triller relies merely on labels and conclusions, formulaic recitations of the elements, and conclusory allegations which simply will not do. Further, Triller's threadbare recitals of the elements of a cause of action supported by mere conclusory statements are woefully inaccurate. This is great, and that's the standard, but below, they've got to show it. Triller cannot, as here, rely on anticipated discovery to satisfy its pleading requirements. Rather, pleadings must assert well-pled factual allegations to advance to discovery. Triller was required to plead sufficient facts to demonstrate that it is not unfair to require the opposing party to be subjected to the expense of discovery and continued litigation. So a motion to dismiss is appropriate to cut off the litigation now so that it doesn't have to become more expensive and complicated. The Ninth Circuit has repeatedly held that on a motion to dismiss, a court can review evidence, etc., etc. The court, there's going to be matters of judicial notice and exhibits and things in here, so they're setting the stage for that. Triller's copyright infringement claim relies on Ethan's statement that he bootlegged or pirated the April 17th transmission of the broadcast. Additionally, Triller's vicarious copyright infringement claim appears to rely on the allegation that third parties engaged in copyright infringement by watching the reference video and the podcast on YouTube. Viewing a transmission, whether it be Triller's April 17th transmission, the reference video, or the podcast, does not constitute copyright infringement. And I started to really get all warm and fuzzy here when I read this, because this is right at the core of one of the biggest, most important parts of copyright that is often so easily overlooked because we're so often dealing with a copy instead of just viewing something, just looking at something. Viewing a transmission is not a public display, not a public performance, not a public distribution, or a derivative work of the original work. Nor does viewing a transmission implicate the reproduction right. So 17 USC section 106(1) is the right to prevent copies. It is the copyright. There are multiple, I think there's 6 of them. The right to prevent copies, the right to prevent derivative works or to control derivative works, and then various public performance rights. And so section 106(1) is what we call copyright infringement, is the right to prevent or control the production and distribution of copies. The reproduction right grants a copyright owner the exclusive right to reproduce the copyrighted work in copies. To constitute a copy, the work must be fixed. A work is fixed when its embodiment in a copy is sufficiently permanent or stable to permit it to be perceived, reproduced, or otherwise communicated for a period of more than transitory duration. This is usually said when we're learning copyright law as it must be fixed in a tangible medium of expression. And so what Lincoln has done here is break that out into what that means. A work is fixed when its embodiment is sufficiently permanent to permit it to be perceived, reproduced, or otherwise communicated for a period of more than just transitory, more than just transitioning from screen to your eyes and then gone. Critically, when a work consisting of sounds, images, or both is transmitted, like the broadcast, the podcast, or the reference video, a copy is only fixed when the fixation of the work is being made simultaneously with its transmission. Congress clarified this point in the legislative history of the Copyright Act. The definition of fixation would exclude from the concept purely evanescent or transient reproductions, such as those projected briefly on a screen, shown electronically on a television or other CRT, or captured momentarily in the memory of a computer. Here, the Second Amended Complaint concedes that the broadcast, reference video, and podcast were transmitted. The complaint alleges that defendants did not simultaneously fix the broadcast with its transmission, and does not and cannot allege that third parties did the same to the reference video or 422.21 podcast. Then it goes on to fair use. The fair use of a copyrighted work for purposes such as criticism and comment is not an infringement of copyright. That's 17 U.S.C. 107, the fair use exception to copyright, which is the way we embody free speech into copyright law. As the Supreme Court explained, the fair use doctrine is an equitable rule of reason, so equity is fairness, so it's a fairness rule, that permits courts to avoid rigid application of the copyright statute when, on occasion, it would stifle the very creativity which that law is designed to foster. And Lincoln here is quoting Google versus Oracle, which was decided just this year. So then they talk about the 4 fair use factors. The first fair use factor is the purpose and character of the use, which includes whether the use is a commercial use or a nonprofit educational use. 2, the nature of the copyrighted work. 3, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. So that's how much did you use in proportion or relation to the original. 4, the effect of the use, the secondary use, upon the potential market for or value of the copyrighted works. And 4 contains in it its own little exception. Just because you made criticism and therefore the market value dropped for the original doesn't necessarily mean that you've lost the 4th fair use factor. These factors are not exhaustive. They set forth general principles, and the application of which require judicial balancing, depending on the circumstances. Fair use cannot be simplified with bright-line rules. The statute, like the doctrine it recognizes, calls for a case-by-case analysis. This is the single most frustrating thing about copyright law. In order to catch the nuances of different uses and things that are fair use and things that are not, every single use has to be reevaluated brand new. You can't say that here's the one I was just thinking about was I just watched the YouTube video about the Kickstarter that was going to make Nintendo game guides with custom original artwork, but it was artwork that was derivative of Nintendo. And the Kickstarter and everything was taken down after a phone call with Nintendo. You can't just say you can never make game guides. You can probably make game guides, but some game guides will be fair use and some game guides won't, and it depends upon these factors. I won't digress further. Nor may the 4 statutory factors be taken or treated in isolation from one another. All must be explored. The results must be weighed together in light of the purpose of copyright. So it's a balancing test. You kind of write down all the things that go for one side and all the things that go for another and see if one weighs more than the other. If it's a tie, good luck. You've got to figure out a way to articulate a winner. The intermediate use doctrine applies. Triller appears to allege that the reference video and defendant's viewing of the broadcast should be viewed in isolation from the use of the broadcast in the 422.21 podcast. And that was one of my major questions when we first saw this. Is it going to be that the reference video is the copyright infringement here and the rest of it is fair use? Here's how Lincoln and Kleins address it. The Supreme Court, Ninth Circuit, and Second Circuit have explicitly rejected the separate approach under the doctrine of intermediate use. In Google versus Oracle, the Supreme Court cited with approval 2 Ninth Circuit decisions for the proposition that intermediate copying, or copying as a preliminary step in the creation of a fair use work, also qualifies as fair use. We all learned something today. This is a pretty cool doctrine. So you can't take those 2 separately according to this citation. Sega, so Sony Computer Entertainment versus Connectix, and Sega versus Accolate. Sega and Sony stand for the proposition that intermediate copying must be examined in light of the overall purpose of the final use. In both cases, the Ninth Circuit found that defendants' copying of the plaintiff's copyrighted software were intermediate copies that qualified as fair use because their primary purpose was to create non-infringing works, new video games. The Ninth Circuit has a quote from Sony. The intermediate copies made and used by Connectix during the course of its reverse engineering of the Sony BIOS were protected fair use necessary to permit Connectix to make its non-infringing virtual game station function with PlayStation games. Any other intermediate copies made by Connectix do not support injunctive relief, even if those copies were infringing. The Second Circuit takes an identical approach and applied it to the use of science articles. I think that's American Geophysical Union versus Texaco. In that case, Texaco made copies of individual articles from a science journal for its research scientists. The Second Circuit characterized the copies as an intermediate use whose primary purpose was to abet the scientists' research. The primary purpose of the copies was not for fair use, however, because the scientists did not quote or cite the articles in their publications or use them in their experimentation. Here, the second amended complaint explicitly concedes that the reference video was used in the 42221 H3 podcast. Further, the podcast, which is incorporated by reference, clearly uses the reference video to comment on and critique the broadcast. Therefore, the reference video and defendant's viewing of the broadcast cannot be viewed in isolation. As discussed below, it is readily apparent that the primary purpose of the reference video and the viewing of the broadcast was to prepare for the commentary and criticism of the broadcast in the podcast. As such, Triller's attempt to view the defendant's acts of infringement in isolation is precluded as a matter of law. Now, of course, Triller gets to respond to the motion to dismiss. There will be maybe 1.5 rounds of responses here, and then the judge will either hold a hearing or decide the thing on the papers. I wrote to Lincoln earlier today, and he said that he felt that they had a strong defense here. So I think they're hoping for a win. I mean, of course they're hoping for a win, but they really think that they're going to get a win here. The first fair use factor. The central purpose of the first fair use factor is to see whether and to what extent the new work is transformative. A use is transformative when it adds something new, further purpose, different character, altering the copyrighted work with new expression, meaning, or message. The Ninth Circuit has also explained that if the allegedly infringed work is used as raw material, transformed in the creation of new information, new aesthetics, new insights, understandings, this is the very type of activity that the Fair Use Doctrine intends to protect for the enrichment of society. Moreover, the more transformative the work, the less the significance of the other fair use factors, like commercialism, that may weigh against a finding of fair use. It is well established that among the best recognized justifications for copying from another's work is to provide comment or criticism of it, and they go on to cite the Matt Haas case, which is just, this is poetry at this point. Indeed, the Supreme Court concurs in Google. A subsequent work is transformative because it comments on the original or criticizes it. In Campbell versus Acuff Rose Music, comment and criticism traditionally have had a claim to fair use protection as transformative works. For copyright geeks, this is a wet dream. This is a beautifully written motion to dismiss, and I'm as proud of it as I'm allowed to be without sounding condescending, because I have nothing. I look up to this. I aspire to this level of clarity in my law practice. Thus, there is a strong presumption that the factor 1 favors the defendant if the allegedly infringing work fits the description of uses described in Section 107, including criticism and comment, again citing to the Matt Haas case. And then there's the Mattel versus Walking Mountain Productions. Works that comment and criticize are, by their nature, often sufficiently transformative to fit clearly under the fair use exception. There's another site here, Section 107 expressly permits fair use for the purposes of criticism and comment. We know that. In the Matt Haas case, the court found that Ethan and Ila's use. It's always great when you can say, hey, my client's been here before, and now that we're here again, let's cite back to what happened before. It's the exact same thing, or something that's at least informative for the court. It just carries a level of weight with it that a lawyer normally can't use. But because the Kleins went through this fight before, they've got this extra bit of fight, this extra trick up their sleeve. This extra move that should be able to knock Triller out of the ring or out of the match. I don't actually know how fights are referred to, so I'm sorry for my attempts at humor and analogy. The court found that Ethan and Hila's use of a YouTuber's video was quintessential criticism and comment, irrespective of whether one finds it necessary, accurate, or well executed. This case is no different. While showing excerpts of the reference video, the cast of the podcast, 1, critiqued Ben Askren's physical fitness, including his ability to box and how he was knocked out by Jake Paul, and 2, critiqued the fight itself, including the mismatch between Jake Paul and Ben Askren, the fight's brevity, and the referee's decision to call the fight for Jake Paul, and whether one of the fighters took a dive. The commentary and criticism surrounding the podcast's use of the reference video further emphasizes the transformative use of the broadcast. The Swatch Group case, the altered purpose or context of the work is evidenced by surrounding commentary and criticism. Prior to showing an excerpt of the reference video, the cast for the podcast made overarching critiques of the broadcast, including its quality and decision to include mainstream musical acts in a fight between a YouTuber and a formal mixed martial arts fighter and wrestler, and 2, directly critiqued Ben Askren's physical fitness to participate in the fight, including comparing his previous physical fitness with his current physical fitness and how this created a lopsided matchup with Jake Paul. It's always fun to deconstruct these things. What is the one quote? Deconstructing a joke is like dissecting a frog. The thing dies in the process. After showing an excerpt of the reference video, the cast of the podcast further critiqued the referee's premature decision to call the fight for Jake Paul and discussed whether the fight was staged, further critiqued the poor quality of the fight and Jake Paul himself, and commented upon the number of reported viewers of the broadcast, its purported revenue, and Jake Paul's financial take for the fight. In addition to the title of the 422 in addition, the title of the podcast transforms the broadcast See Hughes v. Benjamin, which was also a case that we covered. I think I was given the honor of sort of announcing being, I believe, the Morrison and Lee actually sent the Hughes v. Benjamin complaint to me, and I broke the news. And then here I am reporting on what a terrible decision it was for them to file the thing. Anyway, it's now being used as precedent. The motion to dismiss there was granted primarily because of the title of defendant's YouTube video, SJW Levels of Awareness, which served to comment and critique the plaintiff's YouTube video. Yes, the title, but also the editing. The editing was also part of the critique. Here, the title of the podcast was Jake Paul Fight Was a Disaster, and people watched because they wanted to hear the cast of the podcast ruthlessly critique Jake Paul, the fight, and the broadcast. Therefore, like in Hughes, a reasonable observer who came across the video would quickly grasp its critical purpose. Finally, it is readily apparent that the primary purpose of the reference video and defendant's initial viewing of the broadcast was to facilitate the commentary and criticism of the broadcast in the podcast. Without the reference video and initial viewing of the broadcast, the aforementioned commentary and criticism would lose all context and utility. Again, quoting the Matt Haas case, without using actual clips, the commentary and critique here would lose context and utility. This is further emphasized by the reference video being unlisted. The only way to access it was knowing its URL. The podcast did not zoom into it, did not state its URL, did not direct viewers to watch it. Indeed, the only way to access the URL was to watch the podcast and look for the URL and then zoom in, write it down, manually enter it, as said before. It is evident that the vast majority of viewers did not do this because the reference video only received 65 views, less than 0.0065% of the over 1 million views received by the podcast. In sum, the first fair use factor weighs heavily in favor of fair use because it was highly transformative. The commercial use does not weigh against fair use. The more transformative a work, the less significant the other factors, including the commercial use. Hughes is directly on point. In Hughes, the court explicitly stated that the commercial nature of an allegedly infringing work is not necessarily a significant factor. Exactly like Triller, the plaintiff in Hughes tried to argue that the defendant unfairly derived profits from plaintiff's video in the form of advertising revenues generated from its upload to and availability on YouTube. The court rejected this argument and stated, insofar as there is a commercial aspect to defendant's video, it pales in significance to the considerations discussed above, the transformative criticism by defendant of plaintiff's video. Bad faith is not a fair use consideration. Triller will argue that defendant's unauthorized access to the broadcast forecloses defendant's ability to raise the fair use defense, but decisions rendered after Atari and Harper and Row, which apparently Triller cites, the Supreme Court has expressed skepticism about whether such bad faith considerations play any role in fair use analysis. In Google, this year, as for bad faith, our decision in Campbell expressed some skepticism about whether bad faith has any role in fair use. We find this skepticism justifiable. Copyright is not a privilege reserved for the well-behaved. And then citing Campbell, being denied permission to use a work does not weigh against a finding of fair use. Further, the Ninth and Second Circuits have explicitly rejected reading Atari and Harper and Row to require access to an authorized copy to invoke fair use. This was one of my questions about whether Triller was going to be able to say that first H3 had to make an unauthorized copy, and then that's the copyright infringement. And then the rest is fair use. But the original thing was copyright infringement. So this is their answer to that. From the Perfect 10 case, which was one of the, I think it was thumbnail cases. There's a bunch of Perfect 10 cases, and they're not all about thumbnails, I don't think. We conclude that Google's inclusion of thumbnail images, I should have just read the next sentence, derived from infringing websites in its internet-wide search engine activities does not preclude Google from raising a fair use defense, and NXIVM, despite unauthorized access to the copyrighted work, the first factor still favors defendants in light of the transformative nature of the secondary use as criticism. So the second factor, then, typically has not been terribly significant. Triller controlled the first public appearance of the broadcast. The copyright registration states that the date of first publication was April 17th. The 42221 podcast used an excerpt. The second fair use factor weighs heavily in fair use. This is the nature of the copyrighted work. Usually the nature of the copyrighted work is whether it's factual or creative. They're both speaking about a factual thing, a fight that happened. One is a broadcast of the fight that happens and is a live broadcast, and the other one is a live broadcast of someone critiquing the fight. So I don't see how there's really a whole lot to discuss there. I guess there's not. The third fair use factor asks whether the amount and substantiality of the portion used, the secondary use, the podcast, in relation to the copyrighted work, the fight broadcast, as a whole are reasonable in relation to the purpose of the copying. And I usually use the MST3K example. Sure, MST3K would criticize and comment a movie while they watched it, but they also watched the whole movie. So forgetting for a second that MST3K had permission to do what they were doing, if they did not, it would not be a fair use. Courts are tasked with examining the justification for the particular copying done, and recognize the extent of permissible copying varies with the purpose. The Supreme Court recently clarified both the quantitative and qualitative analysis for this fair use factor. So the how much of the heart and the how much of the quantity. As to the quantitative analysis, the Supreme Court explained copying a larger amount of material can fall within the scope of fair use where the material copied is central to the copier's valid purpose. This also requires taking into account the amount the alleged infringer did not copy from the plaintiff's work. As to the qualitative analysis, how much of the heart did they use, even when the secondary user takes the heart of the work, so it was a fight, it was a big build-up to a particular... The headlining act was Ben Askren and Jake Paul. So you could be forgiven for not caring about anything except the match itself, and maybe even those seconds of the match where one particular thing happened. I didn't watch it. I have no idea who did what. They fought. That's all I know. But there's going to be a moment where somebody lands the final blow or something like that, and that's going to be the thing that everybody wants to see. So you take the heart of the thing and just copy that, and that's pretty big. That's pretty bad copyright infringement. But now the answer from the defendants is, even when the secondary user takes the heart of the work, the substantiality factor will generally weigh in favor of fair use when there is a transformative valid purpose. The facts of this case stand on even firmer ground than on the Matt Haas case. I don't know about that one. I think the Matt Haas case was a pretty clear case of transformation, but let's see what the Kleins and Attorney Bandlow have to say. In that case, Ethan and Ela used 3 minutes and 15 seconds of a 5-minute, 24-second long video in their almost 14 minutes long critique. That's the Matt Haas thing. Here, in the podcast, they played only 42 seconds from the reference video, which consisted of 5 seconds of audio, 9 seconds of audio and video, and 28 seconds of just video, and 6 seconds of that was repeated. The broadcast was essentially 4 hours long. In other words, the podcast used less than 0.3% of the broadcast. Therefore, the quantity the broadcast used in the podcast, I think this is a typo here, was little compared to the Matt Haas case. Okay, so I see what they're saying. It's the comparison of the amount used. They're using even less by comparison here. And very reasonable in relation to the podcast's transformative purpose of commentary and criticism of the broadcast and fight. Further, insofar as the fight was the heart of the broadcast, its use, in my opinion, its use in the 422 podcast was tethered to a valid purpose of commenting and critiquing. No different than the Matt Haas case, the court's analysis applies. Quote, "It is evident that to comment on and critique a work, clips of the original may be used. Without using actual clips, the commentary and critique would lose context and utility. Here, the extent and quality and importance of the video clips used by the defendant were reasonable to accomplish the transformative purpose of critical commentary. A great deal of plaintiff's work was copied, but such copying was plainly necessary to the commentary and critique." The third fair use factor weighs heavily in favor of fair use. The fourth statutory factor focuses upon the effect of the copying on the market for or value of the original copyrighted work. Therefore, courts must consider not just the amount, but also the source of the loss. This requires distinguishing between biting criticism that merely suppresses demand. So think of a movie. Somebody comes out with a movie, Cats, and the reviewers go and watch the movie, and then they write scathing reviews of the movie, but in writing scathing reviews of the movie, they have to reveal the characters' plot themes, etc. If someone came along and very stupidly tried to call that copyright infringement, well, this biting criticism that suppresses the demand for Cats is not the same thing as a violation of the fourth fair use factor in favor of Cats. It would be perfectly okay for the criticism to completely destroy anybody's desire to watch the movie. That would not be copyright infringement. That would be that would be consistent with a fair use. So biting criticism that merely suppresses demand, and copyright infringement which usurps it. So copyright infringement replaces the demand with its own. If I copy Cats and I put it out there and I say, hey, pay me to watch Cats, or don't even pay me to watch Cats, like not paid for, free piracy is still copyright infringement. That usurps the demand. You don't have to go watch Cats now because you can get a copy here for $5 from a pirate site or for free from a pirate site. Whereas the critique doesn't replace someone who actually wants to view the thing, despite now reading a bad review. It is axiomatic that market harm from criticism, even if directly translated into foregone dollars, is not cognizable under the Copyright Act. This is because the law recognizes no derivative market for critical works. Criticism that may impair the market for derivative uses by the very effectiveness of its critical commentary is no more relevant under copyright than the like threat to the original market. A lethal parody, like a scathing theater review, may kill demand for the original. Here, the podcast provided scathing criticism of the broadcast and used the reference video to serve that purpose. Again, the Matt Haas case is directly on point. Geez, we wouldn't have all this wonderful case law if Matt Haas hadn't stupidly filed his lawsuit, and apparently if Akilah Hughes hadn't stupidly filed hers. Here it is clear to the court that the podcast does not serve as a market substitute for the broadcast, and they're substituting the works, the broadcast work and the podcast work. So they're using the Haas case and they're substituting the quote. Here it is clear to the court that the podcast does not serve as a market substitute for the broadcast. Anyone seeking to enjoy the broadcast on its own will have a very different experience watching the podcast, which responds to and transforms the broadcast into fodder for caustic, moment-by-moment commentary and mockery. Because the podcast does not offer a substitute for the original, it does not, and indeed cannot, usurp a market that properly belongs to the copyright holder. Hughes is also instructive. In Hughes, the court found that the fourth fair use factor favored fair use because the defendant's target audience, generally political conservatives and libertarians, is obviously not the same as plaintiff's target audience, generally political liberals. So that was Hughes versus Benjamin. They were on opposite political sides. And therefore, there was no reason for plaintiff's audience to watch the defendant's derisively titled video simply because it contains parts of her work. Here, the derisive title for the podcast makes it clear that the podcast did not cater to an audience that wanted to sit back and enjoy the event, but rather to an audience that wanted to hear why the broadcast and fight were a total disaster. To think anyone would watch the podcast as a substitute for the broadcast, or to identify the URL in the reference video, is comically absurd. This absurdity is emphasized by the reference video obtaining only 65 views. This dispels any doubt whether the podcast or the reference video served as a market substitute for the broadcast. The Supreme Court has also recently stated that the market harm factor must take into account the public benefits the copying will likely produce, such as copyright's concern for the creative production of new expression. To promote the sciences and the useful arts is literally Article 1, Section 8, Clause 8 of the United States Constitution, which creates the copyright. The podcast is a work of humorous and biting criticism of the broadcast, which serves the public policy of the Copyright Act to stimulate the creation of new works. Indeed, as the Supreme Court stated, humorous forms of criticism provide social benefit by shedding light on an earlier work and in the process creating a new one. Therefore, the fourth fair use factor weighs in heavily of fair use. Indeed, every fair use factor favors fair use as a matter of law. So then they go on to the vicarious copyright infringement claim. For its vicarious infringement claim, Triller also fails to properly plead that defendants had a direct financial interest in the infringing activity, which is part of vicarious copyright infringement. To satisfy this requirement, Triller must plead a causal relationship between the infringing activity and any financial benefit a defendant reaps. Contrary to Triller's allegations, the reference video did not contain any sponsorships or offer for sale any merchandise, nor was the reference video eligible for monetization because the reference video was uploaded to a different channel, which had less than 1,000 subscribers. Therefore, in addition to the reasons above, Triller's vicarious copyright infringement claim fails. Okay. As a threshold matter, Triller's Federal Communications Act claim fails because it relies solely on legal conclusions and threadbare recitals, like we said before. Further, Triller's FCA claims are barred because Triller explicitly alleges that the broadcast was transmitted to the public via online platforms, the internet, and after the April 17th transmission of the broadcast. Courts within the Ninth Circuit and the Central District of California in particular, where this is filed, have repeatedly held that the FCA does not apply to internet transmissions. Quote, although the internet has been in wide use since the mid-90s, the legislature, Congress, has not extended the reach of the FCA to include transmissions via the internet, and it is not the purview of the district court to insert itself and make this determination. In Zuffa v. Justin.tv, a District of Nevada 2012 case, the defendant had no relationship with the original cable or satellite signal and therefore did not receive or intercept any actual cable or satellite signal or broadcast. As for defendant's users retransmitting the work via internet transmission, the court explained this is not the type of conduct properly addressed by the Communications Act, but by copyright law and potentially trademark law. Further, the court held that Section 605 of the FCA only applies when the defendant extended the point of distribution of the actual broadcast signal distributed over a cable or satellite system beyond its authorized limits. As such, the court found no evidence in the statutory language, other cases, or legislative history that the Communications Act addresses this type of conduct or was meant to bolster or act as a separate type of copyright claim. Therefore, the court refused to extend the law in this manner. Here, Triller's FCA claims fail because the second amended complaint concedes that the broadcast was transmitted to the public on online platforms. Additionally, it concedes that the reference video and the podcast were shown via YouTube, the internet, and were uploaded after the transmission of the April 17th broadcast, i.e., they did not extend the point of distribution. For these reasons, the FCA claims fail as a matter of law. On to the alter ego claims. This is where they're trying to get at the Kleins personally and bypass any corporate protection that might be afforded them. Triller sets forth an alter ego theory based solely on conclusory allegations, mere speculation, not adequately pled, insufficient to defeat a motion to dismiss. Okay, great. To properly plead that TEI was an alter ego of Teddy Fresh, Ethan, and Hila, Triller was required to allege facts that demonstrate, 1, a unity of interest and ownership between the corporation and its eligible owners, that the separate personalities of the corporation and the shareholders do not really exist. And 2, an inequitable or unfair result if the acts in question are treated as those of the corporation alone. As to the unity of interest element, Triller's complaint merely asserts conclusory and threadbare allegations that repackage the alter ego factors first articulated in another case, Associated Vendors v. Oakland Meat Company. None of these conclusory allegations are sufficient to plead an alter ego theory. Further, Triller's SAC also fails to properly plead an unfair or inequitable result. Paragraph 18 relies merely on allegations for the lack of separation between TEI and Teddy Fresh, Ethan, and Hila. Nowhere discusses any reason why continuing to recognize each company's distinct corporate form would sanction a fraud or promote an injustice. Such woefully deficient allegations are insufficient to plausibly allege the inequitable result required for a finding of alter ego liability. Therefore, the alter ego theory fails and must be dismissed. Conclusion: Triller's abuse of the judicial process to punish and silence lawful speech can no longer be countenanced. Triller's lawsuit is retribution for the podcast lambasting the broadcast as a disaster. Ironically, despite Judge Anderson's public chastisement and Triller's numerous opportunities to file a well-pled complaint, Triller persists in filing disastrous and fatally defective complaints, and the SAC is no exception. Since Triller consistently refuses to cease its abuse of the judicial process, it is up to the court to make Triller stop. Therefore, for the reasons stated above, defendants respectfully request this court grant its motion and dismiss the second amended complaint with prejudice. Give me a moment to scratch my nose. So then there's some other stuff that's filed here. Most of it has to do with authenticating evidence, that they're submitting evidence that is true and correct copies. Lincoln attests to true and correct copies of the judge's decision, etc. Asks for judicial notice of things like the other case, the broadcast, the podcast, etc. They file a notice of lodging, which means they sent a hard drive to the judge. And then they have a bunch of exhibits here, but this is just a compendium of the exhibits, which are all basically audio, video, and the YouTube partner program terms, meet and confer letter, and all that, which I don't have copies of. I think that was all sent to the court. And that's it, which I think is a great... It's a great motion to dismiss. It's a pretty epic motion to dismiss using the previous case law created by Matt Haas when he sued Ethan and Hila, created by Akilah Hughes when she sued Carl Benjamin, and using Google and Oracle, which was released earlier this year. And I think that's a really great... I'm going to keep saying it's a really great motion to dismiss. I expect that it will be granted, but there's still a couple things in there. Did they really argue enough about vicarious liability? Did they really argue enough about the alter ego? Those seemed like short sections. I could see a judge deciding that there needs to be something more of a hearing on the merits. Maybe there will be supplemental briefing. From here, the plaintiff now gets to respond, something like within 14. Take longer. There can be motions for extensions of time, as there already were to get here. That's why it took so long to get here. And then there might be an additional round of briefing from the defendants as well. Usually you need some kind of court permission to do that. Sometimes the court already grants permission. Sometimes the court requires you to ask for permission. Halleck's Tears says, I'm normally skeptical, but this one's very persuasive. Yes, this is a very persuasive court filing, in my opinion, and I'm happy to have been able to bring this to you today. Are we actually an hour into this already? Holy mackerel. So yeah, I don't know why I don't see any super chats when I see super chat revenue. There we go. Where is it? Alt Grendel, thank you for the $4.99. So yeah, this is a really interesting development in the H3 case, and I'm looking forward to what is hopefully a conclusion of this. This is not the situation that really needs to go to court. You know, I've been to family court, and one of the things that family court justices and hearing masters like to say is, you know, you guys don't need to be here. You guys need to be able to work this out on your own. This is the kind of thing that the parties should be able to work out on their own. If there was a violation, even sort of a perceived violation, they should be able to talk about it and work it out. But it sounds like Triller is unwavering in his desire to flatten the H3 defendants. That's just my perception of it, because why would they be coming on so strong? Why would they have filed this so quickly when they have a 3-year statute of limitations to figure out what's going on? Instead, it seemed very quickly done. And one of the motivations for that could be trying to stifle the Kleins speech. And now that we know that they've moved into LA Superior Court with a tortious interference claim, tortious interference would be when you interfere with someone's contractual relations or business relations unlawfully. And you're usually not supposed to be able to bring multiple different claims for the same infringement. So if they brought a tortious interference claim, but it sounds like a copyright infringement claim, well, then we have something called federal preemption, where federal law should override and overrule the state law. So if the Kleins are guilty of copying something, and that copying is also tortious interference of a contract or just whatever kind of tortious interference with business relations, then the claim should be kicked out of Superior Court and should be brought back to the Copyright Court. You might be able to do this through what's called a notice of removal, where you remove the state court claim into federal court, and then the federal court has to rule on whether that was proper or not. Instead, it sounds like they're going to file an anti-SLAPP motion, maybe because an anti-slap motion is easier and might be easier to grant the defendant their fees and costs. So anyway, that's an hour of copyright jurisprudence, thanks to Lincoln Van Lowe and the Kleins, and of course thanks to Triller for bringing it to us in the first place, though I wouldn't want to wish that on even my worst enemies. We are lawful masses and our mods and our contributors and our supporters and our viewers. We are Lawful Masses, a legal education program here on YouTube. And if this is your first time with us here, I'm Leonard French. I'm an actual copyright attorney, and I call myself your favorite copyright attorney, tongue-in-cheek. Started out as a sarcastic thing. It's still kind of a sarcastic thing, but many of you do profess that I'm your favorite copyright attorney. Lincoln Van Lowe is currently my favorite copyright attorney because he did such a great job on the motion to dismiss here. And I look forward to seeing it adjudicated. And I'll bring you those steps along the way. We'll see what Triller has to say when they respond, and we'll see what the court has to say when the court rules. Hopefully, that's the end of the thing. Thank you very much to our supporters on patreon.com/ljfrench, sponsus.com/law. We also have YouTube membership, and we have Floatplane subscriptions to support the channel. In the month of September, special thanks to our top supporters, our $50 plus supporters: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, ShadowTycho, Earthbound Star, PureMagma, Drew Hart, TechTechPotato, and Eric Tams. The rest of the supporters, the $5 plus supporters, are in the description of the video. I love you all. I will see you in the next one. Thank you for watching.